Good afternoon, everyone, and welcome to today's masterclass, another installment in the ENS Africa CPD Masterclass series. For those who are joining us for the first time, my name is Jessica Blumenthal, and I'm a director in the Banking and Finance Department at ENS Africa. For those of you who've already been on the previous 8 masterclasses, thank you for joining us again, and thank you for bearing with me as I do this introduction that you've probably heard several times. For the last 3 years, the Banking and Finance Department has presented a CPD series for those in the financial services sector who are required to undertake continuous professional development, key individuals and representatives. And this masterclass, as with all the masterclasses in the series, has been accredited. And so if you remain with us for the full hour of the presentation, you will be able to get a CPD verified certificate for having attended this masterclass today. Please do note that we do need to verify your attendance, so please do stay online for the full duration. The intention behind providing the CPD series is, of course, to assist the financial services sector to ensure that they attain their CPD hours, but also to use the opportunity to canvass topics which we believe are important to the industry. And for the last 2 years, we've been focusing on the very hot topic of ESG. Last year, our CPD series was very much introductory. We used it as a platform to raise awareness for emerging risks and opportunities. And this year, we've decided to take the opportunity to delve a bit deeper. So we've been bringing together panels of experts to present masterclasses in what we think are some of the emerging risks facing the financial sector and, in fact, all sectors today. So as I said, this is the 9th installment. There are still several masterclasses upcoming, so please do register if you'd like to join us for those. And I'm very happy today to be welcoming Stephen Powell, who heads up ENS Africa's forensics practice, and Adrian Roux, a senior associate in that practice as well. Stephen and Adrian are both well-known forensics lawyers, and I'm not going to steal their time by reading out their CVs. I will share them with you in the chat, but they really are true experts, and it's wonderful to have them to talk to us today. They'll be talking about sanctions, certainly something very topical in the press at the moment, and something that should be on everybody's risk register to watch, the effect of sanctions on a business and on a supply chain. And Stephen and Adrian will be unpacking that for us today. In addition to being forensic specialists, they are both part of ENS Africa's ESG practice group as well. And as part of that group, which is a multidisciplinary group made up of practitioners from different practice areas, Stephen and Adrian help drive the conversation, particularly around governance factors, bringing in their knowledge and their expertise, both in an anti-bribery and corruption context, as well as in an anti-money laundering context. And it's the bringing together of practitioners like Stephen and Adrian and the other practitioners making up the group that allows for a diverse perspective, and it allows us to consider ESG and sustainability related issues holistically, ensuring that we can continue to offer innovative solutions. So I'm glad that you have the opportunity today to meet Stephen and Adrian and to learn from them. Please do remember, if you do have questions that you'd like to ask during the presentation, you can put them in the Q&A block at the bottom of your screen. They've got quite a packed schedule of an agenda to get through today, so we may not be able to take questions, but they will touch base with you privately after the session if you do have a question that needs answering. So please do use the Q&A block for that purpose. As I mentioned, you will get a CPD certificate if you remain online for the full hour. So please do that if you'd like a certificate. Our team sends them through usually 2 days or so after the webinar. And finally, just an invitation, you would have seen it at the start of this webinar. We are hosting a cocktail party at the end of this masterclass series. And really that will be an opportunity for you to meet the panelists in either Cape Town or Joburg, depending where you are based, and to ask any of the questions that you perhaps didn't want to put in the Q&A block and you wanted to hear the answers straight from the horse's mouth. So please do join us for either of those functions. And yes, and register for the further masterclasses if you'd like to do so. So let me hand over now to Stephen. And Stephen, please take it away. Thank you very much.
Thanks so much, Jessica, and welcome everybody. I see a lot of familiar faces in the audience today and many clients that I haven't met previously. We're hoping to provide you with some background and just some guidance in terms of the ever-changing sanctions compliance environment. The Russian violence, the war in Ukraine, has led to a plethora of sanctions being issued almost on a weekly basis, and staying on top of these is a challenge. It's a compliance nightmare. I always joke that the medical aids need to recognize a new type of disorder. We call it compliance stress disorder. And sanctions is just one of the risks that it is very difficult for compliance officers to stay on top of. But the good news is that help is at hand. So please do reach out if you need any help developing policies or getting guidance. Many of our clients have existing relationships with Russian entities, and sometimes some of those individuals have ended up on sanctions lists, and then it becomes a nightmare trying to exit those relationships. And we've had quite a significant amount of experience in navigating those risks. The sanctions landscape has evolved rapidly, and it's going to continue to evolve as we move forward. So it is complex, and what is very, very scary is that some of the sanctions can be very draconian, and there are sanctions that are imposed on individuals. It's very easy to be added to a designated list, and it's incredibly difficult to get off those sanctions lists. But what is important for us as a business is to make sure that we are screening and making sure that we take proactive steps to mitigate the risk of contraventions of applicable sanctions. Today, we're going to focus really on South Africa, and the South African section, which I will do, is very, very short and sweet, because the reality is South Africa is not doing terribly much when it comes to sanctions, but we'll also unpack the UK and the US, which are two jurisdictions that have imposed global sanctions that have extraterritorial reach. And for many of our organizations that has touch points, associations with the UK and the US, it is important to always make sure that you're on the right side of navigating those sanctions. I mentioned there's not much happening in South Africa, and I've explained that businesses need to navigate and make sure that they don't end up on the wrong side of sanctions. I am, however, very, very nervous about what our government and our country is doing, because we seem to have, well, we claim to have taken a neutral stance when it comes to Russia and the conflict, but we have taken a few steps which has alienated us from some of these jurisdictions like the UK and the US. And the US in particular has been rather peeved at some of the overtures. We all saw the naval exercises that took place a few months ago. And many of you may not have noticed last week, a Russian plane slipped into Waterkloof Airport. And that was raised by the Americans. They're very, very upset at that. And South African officials allowed a cargo plane that was targeted by US sanctions for supporting Russian military efforts to land at Waterkloof in Pretoria last week. And this can escalate the tensions between the US and SA. We've seemed to have successfully navigated just the debacle caused by the invitation to President Putin to attend the BRICS conference. And fortunately, it now seems that he's going to attend that online, which is a good call for South Africa. But this latest, I think, just drama escalates the risk of South Africa being sanctioned. And that's obviously out of our control. What we are seeing is that the world is clamping down on the Russian government, and we've seen massive forfeitures, seizures of assets belonging to Russian oligarchs. The Russian oligarchs have been accused of enabling and supporting the Putin regime. And Victor Vekselberg had his yacht, the Tango, seized. That was seized in Spain. The Scheherazade, the yacht owned by President Putin himself, was seized in Italy by the Italian government some time ago. And we've also seen that Monaco, which had many of the oligarch yachts birthed in the yacht club, that is virtually empty. I think it's 12% of what it was just a year or two ago. And many of the Russian super yachts have moved to the Maldives and other jurisdictions which are more friendly to the Russian government. If we contrast that approach, the global approach, to what South Africa is doing, I think we're on a precarious path, and the US government has already tabled motions in their Senate to reconsider AGOA and the trade relationship with the US. And just the last point on the trade, when we look at our trade with the US is our largest trading partner, and we trade to the value of about $6.5 billion per annum. And if we compare that to our engagements with Russia, we have a trade deficit of 210 million. So it doesn't seem to make any economic sense to alienate the US government or to align with the Russian government. But that is where we find ourselves. And now, if we look at the sanctions framework in South Africa, we do not have an autonomous or domestic sanctions regime. We do have two targeted financial sanctions regimes, which all of us need to understand, and these flow from the terms of the charter of the UN sanctions, the UN Charter, and the two pieces of legislation that we obliged to comply with. It is undertaken through the protection of constitutional democracy against terrorist and related activities, and the abbreviation of that is Pocatara. And then we're all familiar with the FIC Act, our Anti-Money Laundering and Counter-Terrorist Financing Framework, which is established by the Financial Intelligence Center Act of 2001, the FIC Act. And through these acts, we implement the UN Security Council resolutions. The difficulty with the UN resolutions is that there are a number of permanent members of the United Nations Security Council. There are 5 permanent members, and Russia is one of those permanent members. So Russia always has the power to veto resolutions. So if there ever were to be proposed sanctions against Russia at a United Nations Security Council level, the Russians would be able to veto that. And so it's not surprising that we're not seeing any sanctions coming out of the United Nations Security Council. The jurisdictions which the UN Security Council has managed to impose financial sanctions on are Afghanistan, Sudan, Iran, Yemen, and many others, and these relate to political, security, and humanitarian concerns in those jurisdictions. And there you see on this slide, the UK, US, France, China, and Russia are the permanent members. And as I mentioned earlier, Russia has this ability to veto any action proposed against Russia. In terms of Pocatara, Section 4 of Pocatara sets out the offense of financing terrorism and indicates that any person who acquires any property, provides financing and or other services and or benefits to a person or entity listed in terms of Section 25 of the Pocatara pursuant to a United Nations Security Council resolution is guilty of an offense. And Section 4 is broad in its application, and it applies to any person, which includes, amongst others, private and public companies. And there you see the penalty for non-compliance with Section 4 of Pocatara. It's very, very serious. And it's an offense which on conviction can result in 15 years. So it is incredibly serious. And maybe I should just bring in the grey listing at the moment, because one of the criticisms of South Africa in the mutual evaluation report that was issued by the FATF in October 21 identified that South Africa has zero identification of terrorist funding activities. And they said this was one of the major criticisms which enhanced the decision to grey list South Africa. That low conviction rate for terrorist funding is inconsistent with our profile, and the global powers are aware that there are many, many terrorist activities, terrorist cells that operate in South Africa and other parts of Africa, and we're not detecting that. The other piece of legislation which ties into the UN Security Council and South Africa's obligation is the FIC Act. Section 26B of the FIC Act prohibits any person directly or indirectly from acquiring, collecting, using, or owning property which such person knows or ought reasonably to have known or suspected was owned or provided for the benefit of or under the direction of a person or entity identified in a United Nations Security Council resolution. And then Section 26B of the FIC Act does not apply to UNSC resolutions contemplated in Section 25 of Pocatara. And there you see the penalties: non-compliance, 15 years imprisonment, or maximum fine of 100 million. So I think in essence, what I am telling you is there is limited sanctions activity coming from the South African government, and the South African government itself is treading a precariously dangerous path by cozying up to countries like Russia that are subject to extensive sanctions. I'm going to hand over to Adrian in my team to walk us through the sanctions framework in the United Kingdom and the US. And just bear in mind that in addition to the US and the UK, we also have a plethora of sanctions coming out of the EU. We're not going to traverse the EU sanctions today, but when you consider your mitigating steps to manage the sanctions compliance risk, it is imperative that you are subscribing to databases that screen against this global terrain of ever-changing sanctions. Over to you, Adrian.
Thanks so much, Stephen. And I think it's a good segue, the mention of the South African government's latest, less than ideal, if I can call them that, movements in respect of, our stance on Russia and the situation in Ukraine, because what it does is it really shines a spotlight on South Africa, and that includes businesses doing operating in South Africa rather, and it just enhances the risks of investigations by the US or UK regulators, and it just means that everyone operating in the space really need to sharpen their pencils and make sure you are doing everything you can to mitigate the risk of a sanction contravention. So as Stephen said, I'm going to first commence with a walkthrough of the UK landscape. The first point of differentiation from the situation in South Africa is obviously that the UK does have an autonomous sanctions regime that they maintain themselves. The primary legislation governing sanctions in the UK is SAMLA, which is the Sanctions and Anti-Money Laundering Act. And what SAMLA does is it empowers ministers to make regulations which deal with specific areas. And the SAMLA is very broad in how it's worded. So the sanctions regulations can be made to govern interests of national security, the promotion of democracy, etc. So very broad concepts, which really provides the UK ministers with a huge scope to introduce regulations and sanctions which they need to in response to particular concerns. There is a control in terms of the ministerial power. They have to lay the draft regulations before both houses of Parliament in the UK, and they must be approved, and thereafter they will become operative. But this is a separate, it's important to just draw the distinction between particular sanctions regulations in response to particular concerns. Take obviously the war in Ukraine as an example, to the process of designation. The process of designation doesn't follow a parliamentary process. It's not protracted. As soon as there is an identified breach, a particular person or entity could be designated. So that part's very quick. It's just the process of introducing the particular regulations to deal with a new threat that might take a bit longer. But SAMLA contemplates 5 categories of sanctions. You've got financial sanctions, immigration sanctions, trade sanctions, aircraft sanctions, and also shipping. The focus for most persons, or the biggest concern, is typically financial sanctions. That's where there's the most cause for concern when it comes to financial penalties, etc. for contravention. And in terms of enforcement, this will depend on the nature of the underlying sanctions. So for financial sanctions, which, as I said, is typically the biggest focus, that's OFSI, which is the Office of Financial Sanctions Implementation. Of interest as well, and I will get to it shortly, is immigration sanctions, and that is obviously implemented and enforced by the Home Office. So, what sanctions have the UK imposed so far? As I said, SAMLA lays the groundwork for very broad potential regulations to be made in accordance therewith. An interesting early example was the global human rights sanctions regulations, which were made in 2020. Some of you may be aware of the story of Sergei Magnitsky. He was a Ukraine-born tax advisor based in Russia that was assisting with an investigation into the fraudulent seizure of certain investments belonging to the US investment firm Hermitage Capital. What happened there is the Russian authorities came in, they conducted these unlawful seizures. Everyone associated with Hermitage was obviously concerned for their own well-being and fled the country. Sergei Magnitsky stayed behind. He refused to cooperate with the authorities. He refused to provide the false testimony that was being requested of him. He was thereafter detained. Russia provided for detention of 1 year without charge. 7 days before he was due to be released, he actually died in custody, and it later transpired that he was beaten by the Russian officials. And what happened there, obviously it's a tragic story, but the legacy that's flowed from that, the founder of Hermitage Capital, Bill Broder, he was personally aggrieved by this, felt personally responsible, and went on a campaign petitioning various government officials in the US to try to get some sort of justice for Sergei. And this ultimately culminated in the Magnitsky Act in the US. And what's very novel about how this operates is, obviously, a lot of the very powerful persons in Russia are immensely wealthy. So the question is, well, how do you punish these individuals? And the Magnitsky Act sought to do that through a combination of asset freezes and travel bans. So no more coming over to Beverly Hills to go on a shopping spree, when you are personally culpable indirectly or directly with human rights violations. So that was quite a landmark a development in the law. And what the UK did is they implemented their own version of that, and that's the Global Human Rights Sanctions regulations. So there you can have the regulator adding people to designated lists for human rights violations. Then quite well known to persons in South Africa are the Global Anti-Corruption Sanctions regulations in the UK, which were introduced in 2021. And it was those regulations that were used to designate the Guptas and Selim Esso as well, in response to the state capture saga in South Africa, which we are all aware of. And then on the topic of Russia, the Russia sanctions regulations in 2019 have been continually amended to keep abreast with the evolving situation in Ukraine, and have largely kept up to pace with the US, and have really just expanded to be quite expansive regulations. So in terms of financial sanctions, OFSI maintains a consolidated list of all individuals and entities who have been designated, and we will get on to, what do you do to make sure that you aren't engaging with any of these persons, and Stephen will walk through some of the due diligence steps, and I'll get to it shortly. What the UK have done is they've published a very useful guidance in terms of, what is appropriate due diligence, and what should you be doing, and what's expected ultimately of companies to avoid inadvertent sanctions breaches. So on the question of who must comply, all persons within the territory and territorial seas of the UK is the official definition, or UK persons wherever they are in the world. So if you've got a registered office in the UK or a subsidiary incorporated in the UK, that's a clear link. But it's a little bit more complicated than that, because you're always going to have to establish, is there any UK nexus? And it's similar to the case with the UK Bribery Act. It can become quite a complicated factual analysis. So it's not as simple as, we aren't in the UK, we don't need to worry. It really does require some thought. And there's a possibility of both civil and criminal enforcement in the event of a breach. In terms of criminal penalties, it can be up to 7 years in prison, and the civil penalties are calculated as either 50% of the value of the breach, which is typically the funds transferred in contravention of sanctions, or £1 million, the greater of the two. Last year, we saw quite a substantial development in this area, which made the overall sanctions landscape much more risky for businesses in terms of your potential liability. And what happened here is the Economic Crime Transparency and Enforcement Act introduced a few key changes to how liability could come about. So the first one was the existing requirement that you knew or suspected that you would be acting in contravention of a sanctions breach. Sanctions law was removed. So effectively what this amendment did is it introduced a strict liability regime. So even inadvertent breaches, so say you enter into a transaction that's with a person that's on one of the designated lists, you can be held liable for that breach, irrespective of whether you knew, which is, on the one hand, quite draconian. On the other hand, you can take it, in favor of the UK regulators. There's an enormous evidential burden that they carry. So the idea is to shift that onto large organizations or any organization that is ultimately viewed to have the responsibility to conduct appropriate due diligence. The other interesting one to note is that the OFSI or OFSI can now publish a notice where it believes, on a balance of probabilities, that a person has breached sanctions law. So if OFSI hasn't gone so far as to find that there has been an actual breach, if they just merely suspect on reasonable grounds that there has been this contravention, they can publish essentially a name and shame notice saying, look, XYZ Limited has engaged with this party. We have cause to believe that this is a contravention. And this is quite substantial, in terms of risk, because the reputational fallout that can flow from this, even if you haven't been found guilty of a contravention, if you've got a notice that mentions that's really not a good look. So quite aggressive changes from the UK government, but you can understand why in the context of the broader global situation at the moment. So I mentioned that the UK government published a guidance in respect of monetary penalties, and within this guidance there is further information on what is appropriate due diligence and what do you need to do to avoid the risk of a sanctions, an inadvertent sanctions contravention. So what the guidance says is that the approach of OFSI will be a fair and proportionate one that best enforces the purpose of the particular regime. So again, we'll have recourse to the particular sanctions regulations that we're looking at. There isn't a closed list of specific factors that you need to take into account, but there is quite extensive guidance. And it really comes down to KYC, which is, who's your customer, or who's the counterparty rather in your supply chain, wherever they are. Do you have full line of sight? Do you know who you're doing business with? But there are also some mitigating and aggravating factors that are linked, mentioned in the guidance, which go to, the quantum of the penalty and, any other consequences which may flow from a breach. And one of the key mitigating factors that's mentioned is that there's evidence that you've conducted appropriate due diligence. Another one is early voluntary disclosure to OFSI. And what they say is that this must be done as soon as is reasonably practicable after discovery of the breach. But they do, and this is quite important, they do acknowledge that it is reasonable to take some time to assess the nature and extent of the breach or seek legal advice. So they obviously want you to report immediately, but they are realistic and have expressly mentioned that it could be reasonable to first understand what have we done, who have we engaged with, and to get legal advice first on the extent of any breach that might have occurred. Contrary to that, the aggravating factors are not carrying out due diligence, particularly high value breaches, high level of harm flowing from the breach, regulated industries that have committed a breach, and obviously repeated, persistent, or extended breaches as well. And then finally, the intentional aim to circumvent sanctions is specifically mentioned as a particularly serious aggravating factor. So where it becomes interesting for those, particularly in the compliance space and those trying to minimize the risk for businesses, is what do they consider appropriate due diligence? And the guidance says, obviously we'll look to the degree and quality of the research conducted. They aren't prescriptive in terms of the actual level, because this is always going to be risk-based. It's going to depend on the organization. It's going to depend on who you're doing business with, etc. But what they do is mention specific factors which are typically associated with appropriate due diligence. Just before we go through those factors, what is mentioned in the guidance is that if OFSI is investigating a sanctions breach, and it's now the organizations, defending themselves and saying, look, we had no idea, we did everything we reasonably could, OFSI is going to look to, was there a clear decision-making process that firstly identified the particular sanctions risk, considered what would be appropriate in response thereto. They're going to need to see that paper trail. They also are going to want to look at whether there's an existing internal framework or policy. So these are all little hints that can be extracted to help bolster the existing compliance program within the organization. Because if you make sure that your internal policies are aligned as closely as possible with this essentially cheat sheet in terms of good due diligence, you're really minimizing the risk of a significant monetary penalty in the event that there is a breach. So the efforts, as they're called, that are referred to in the guidance, including a proper examination of the formal ownership and control mechanisms of the entity that you're doing business with, an examination of the actual or the potential for influence or de facto control over an entity, conducting open source research, where appropriate, direct contact with the entity to probe who's actually in control, and all of this coupled with regular checks and ongoing monitoring. So what they're really getting at here is you need to do effective due diligence, and you really need to understand who you're doing business with. It's not enough to go, stop at the level of making sure you know the name of the particular entity. Who's the warm body right at the top of the ownership structure? Are there multiple parties involved in the particular supply chain? If so, where appropriate, again, this is always going to be risk adjusted and based on the particular risks associated with a transactional industry that you're operating in, or even jurisdiction. Where appropriate, this needs to be extended right up the chain, and you need to make sure that you know who you're doing business with, because this will feed back into the checks that you're running through compliance databases to make sure you're not dealing with sanctioned persons, etc.
Adrian, can I just jump in and just add, a number of the cases that we've been working on has involved transshipping. We see there's a lot of Russian oil at really low prices, as you can well imagine. And so what is happening is that the Russian exporters are going to devious means, they're resorting to devious means to conceal that Russia is the origin of the oil product. So you'll see transshipping, things purportedly come from Morocco, Algeria. But if you dig a little deeper, you'll see that ultimately the source was a Russian source. And you've got to be mindful of that. And in your own due diligence processes, you can't ignore if there are red flags which indicate that Russia was the source of the product, and potentially that may lead to engaging with parties that may be on a sanctions list. You've got to make sure you're doing the homework. The other area that we've also provided extensive advice is even as far back as 2017, 2018, when OFAC started imposing sanctions on US sanctions on the Russian oligarchs, what we immediately saw was a sell down of shareholding to conceal and hide the majority shareholding held by the Russian oligarchs. So we saw mining houses that have operations in South Africa that were owned by Russian oligarchs. Suddenly there was a change in directorship. And when you drill down into what actually transpired, you'll see that the mine managers and people with no financial means to actually pay for their shareholding were on paper the new directors. So, whenever you confront these types of scenarios, make sure that you're doing enough to probe so that if you ever are under scrutiny by a regulator who is questioning your engagement with a sanctioned individual or entity, you're able to defend your position and you don't just accept at face value things that are patently false. Thanks, Ed.
Perfect. Thank you, Stephen. So I'm going to move on to the US now. similar position to the UK in terms of the fact that they do have their own autonomous sanctions regime, perhaps even better known than the UK, and perhaps known for the extent to which they assert their jurisdiction abroad. The primary body that's charged with administering and enforcing US sanctions is OFAC, which is the Office of Foreign Assets Control, which is an agency within the US Treasury Department. So in terms of how the US communicates or sets its policy objectives, that's primarily through presidential executive orders, which will outline, this is the policy statement. And from there, OFAC will seek to enforce the particular stance by way of sanctions enforcement. So to date, OFAC's imposed various direct sanctions on entities and individuals in response to the Russian, the war in Ukraine, rather. But I just want to pause there and just, I think, reiterate or emphasize that there's a lot of emphasis on the situation in Ukraine, rightfully so, and a lot of the discourse has been dominated by the situation in Ukraine and the global sanctions response in respect thereof. But it's important to remember there are a lot of other sanctions currently in place as well. So you need to keep abreast of those and just be aware of the fact that there is this broader regime beyond the response to the situation in Ukraine. I've got a couple of examples. The hard drive manufacturer Seagate entered into a $300 million settlement in respect of a breach of sanctions in that they supplied hard drives to Huawei. And then also there was a approximately $600 million penalty for British American Tobacco in respect of the supply of goods to North Korea. So other things are happening in the background. And why I mention it is, if you're confident you don't have any link to Russia, whether direct or indirect, that doesn't mean that there isn't a risk from a sanctions perspective as well. Not to be too doom and gloom, but it's important to just be aware of the really far-reaching extent of the sanctions landscape. And I saw somewhere the new sanctions enforcement regime has been described as the new FCPA, so the new Foreign Corrupt Practices Act, because if you look back the last 10 years or so, the quantum of the FCPA enforcements that we've seen have been huge, hundreds of millions or even billions of dollars in fines and other penalties. And we're now seeing the sanctions regime, starting to really, I guess, catch up in terms of the quantum. And it's not just about the consequences that flow from being designated and asset freezes, etc., on a smaller level. It's also the enforcement side where there's been a breach, where you're engaging with someone that's been designated. So it's a very expanding and constantly changing landscape. But just the last point to leave with is, it's not just about Russia. It's not just about what's happening in Ukraine. It's really a lot bigger than that. So in terms of, how do you know who you're not allowed to deal with? OFAC maintains a register called the SDN list, so the Specially Designated Nationals list. So if someone's found to act contrary to US policy objectives as communicated in the executive orders, they may be designated by OFAC. And the consequence thereof are typically that your assets will be blocked, and other US persons will be prohibited from dealing with you. So that's quite a critical point, because say you don't have any link to the US, you're not a US person, you don't have a presence in the US or anything like that that establishes this clear jurisdictional link. If you act contrary to US policy objectives, you can be designated. So there's no direct penalty. You haven't breached anything because you aren't within the US's jurisdiction, but that doesn't stop them from designating you. And what that means is other entities then can't do business with you, because then they would be acting in contravention of the particular sanctions regime. So that's what's called secondary sanctions, and it's quite a significant risk. And if I just go back to what we discussed at the very beginning with what's going on in South Africa and our stance in response to the Ukraine war, there's potentially an increased risk now of us being on the radar of OFAC, etc., and the risk of entities that have got clear links to Russia, as an example, being designated. You haven't committed, any breach of sanctions. You don't have a link to the US, but you're designated because you are conducting yourself in a manner that's contrary to the US policy objectives. So that's another avenue for OFAC to try and push the US policy objectives. Then just if we
Adrian,
quickly spoke, yeah, Stephen, go for it.
If I can add, there was a warning from the US ambassador recently, a couple of months ago. She visited South Africa and issued exactly that warning to South Africa. So it just brings into focus just the risk, how precarious the path that government is treading can be for our country. And one of the things I just want to mention, we have helped a number of designated individuals to try and get off the designated list with OFAC, and it is tremendously difficult. OFAC are understaffed, they have a very small complement, and they struggle to keep up with the ever-changing increased sanctions that are issued, and trying to get an entity that was sanctioned off the list is almost impossible. So once you're on that list, you can almost just understand that you're going to be on that list for a considerable period of time. And it is very, very draconian. On one of the designated individuals that we acted for, the designation was based on info that the US government had received from a source that had previously proved to be reliable. And the individual denied the allegations, but the plea fell on deaf ears. Thanks, Adrian.
Thanks, Stephen. So I think we've discussed the Russian situation at length, when we went through the UK legislation, but just briefly, in 2022, President Biden issued a new executive order, and what we saw in the months that followed the invasion by Russia in Ukraine, there were a few executive orders, and they got gradually more expansive, and then what we ultimately got in the end was a prohibition on any new investment in Russia by any US person, wherever they are located in the world. And the term new investment has been defined by way of a response to an FAQ, and it's incredibly broad. I won't go through it in detail, but essentially you can't go and do any new business unless you're unwinding an existing operation in Russia and trying to exit. It's just a no-go. If you are obviously a US person or if you have any clear links, but as I said, there's that secondary sanctions risk as well, which means that even if you don't have that jurisdictional link to the US, it's not really a good idea to be pursuing new investment in Russia now, because you're really going to be on OFAC's radar. And here's just a definition of what a US person is. This will vary per executive order, but it's typically any US citizen, a lawful permanent resident, or entity organized under the laws of the US, or any person present in the US. But what we've seen with sanctions and also with the FCPA is that the US has been very aggressive in how they've asserted their jurisdiction, and they will find a way, if they want to bring you within the ambit of the particular legislation. We've touched on secondary sanctions already, and in addition, I suppose, to the risk of your counterparties not doing business with you because you are placed on one of these designated lists, there's obviously a huge reputational risk that comes with that as well. So I'm going to hand over now to Stephen just to run through the consequences for contravention, and then just to walk through the good side, or the good news, which is, what can you do to minimize all these risks that are present as a result of the ever-changing landscape. Thanks, Stephen.
Thanks so much, Adrian. And I just want to touch on the last point you made around rep risk, because a lot of South African companies take a view that currently the South African government has not taken a hostile approach to engaging with Russia, and many companies do business and continue to do business with Russian entities that are not sanctioned, and it is perfectly legal to do that. But I just want to touch on the reputational risk that comes with that, because there are individuals like Professor Jeffrey Sonnenfeld, he's a Yale professor, who published a list of entities that continue to trade with Russia. And what has happened is that companies on the Sonnenfeld list, their stock value plummeted. They suffered major damage to their share price as a result of the continued association with Russia. And that's something to bear in mind. That list is updated regularly, and a lot of the large multinationals that were on the list reconsidered, and they took steps to exit. And exiting existing relationships with Russian entities is also quite expensive. You know, many companies like BP, Citibank, etc., when they published their financial results, they took impairments running into billions of US dollars, and that was the cost of exiting. And it's almost a balancing act that companies need to achieve. What is the cost of exiting versus what is the cost of not exiting? So managing rep risk is also very, very important. And you'll see it's important when it comes to mitigating steps that you have the ability to terminate existing relationships based on reputational risk. And hopefully you've got clauses in your contracts which dictate that the entities that you engage with are screening and they're going to be sanctions compliant. The non-compliance risk, Adrian touched on the secondary sanction risk, which is a big risk. And what you always have to keep in mind is that the financial institutions, the accountable institutions in terms of FIC, and remember as well that as a result of the grey listing, we've expanded the list of accountable institutions. So there are sectors like diamond, gold trading, which also have to adopt enhanced anti-money laundering risk measures. And those entities are going to flag suspicious transactions or transactions with potentially sanctioned entities. And if you do that, you're at risk of being reported by your financial institution, your bank, which one, blocks the transaction, and two, reports it to OFAC or to OFSI. So, you know, the penalties are significant, and these financial sanctions can be imposed on individuals, governments, and entities. And we see the record is held by BNP. They paid 9 billion and they forfeited 8.83 billion in revenues and were put on a 5-year probation in 2014. And OFSI can also impose civil penalties of up to the greater of £1 million British pounds, or 50% of the estimated value of the funds. So it is important for organizations to take proactive measures to mitigate the risk of sanctions violations, and the screening is absolutely essential. If we look at prior OFAC actions, there are 3 areas that were consistently identified by OFAC as being a mitigating factor when it came to penalties. And so improving your compliance environment, that's always regarded by OFAC, and very similar to what we have with FCPA, you need a sanctions compliance program. So for those of you who have touch points with the US and the UK, it is important that you do a sanctions risk exposure, a sanctions risk assessment to determine the exposure, and make sure that you've got a sanctions policy in place. And then what is also looked at by the regulator is management's response to violations. If you are transparent, act quickly and decisively on discovery of a sanctions breach, that'll put you in a more favorable position when it comes to the determination of financial penalties. The US always tries to encourage self-reporting, and that's an area where you will need to get extensive legal advice. And it's also a balancing act, you know, so everything will depend on the facts. And then cooperation with OFAC. Companies that demonstrate a transparent approach and interact with OFAC, they are also treated more leniently. It's essential for organizations to implement proactive sanctions controls. And the first is having those internal policies. So if you don't have a sanctions policy in place, it is something you need to consider, and it's something that should tie in to anti-money laundering, anti-terrorist funding, as well as anti-corruption. and it should be part of a broader compliance program. But many companies have never given sanctions a moment's thought, and many of us are at risk that we may inadvertently be violating sanctions compliance. So we've got to make sure we train people, particularly areas like procurement. When we onboarding, it's very easy to close the gates of entry to new entries and to ensure that we're screening and making sure we don't engage with sanctioned entities. But it's also important to have a look at your existing database and make sure that you aren't at present involved in providing services or goods to sanctioned individuals or entities. And then conducting periodic sanctions compliance reviews, risk assessments, and transaction testing to make sure that funds are not being paid to sanctioned entities. And then ongoing due diligence screening procedures on new and existing third parties. And when you're doing large transactions, it's important to do a deep dive, not just a superficial due diligence, and then robust contractual controls. So you've got to have sanctions compliance clauses in your agreements. And if you don't have them in your existing contracts, then I think it is important that you speak to legal advisors and get help. And when in doubt, get legal advice. This is a complicated landscape to navigate. And these areas where I mentioned earlier how the Russians are becoming resourceful and concealing Russia as the source or point of origin of goods that they try and export, you've got to make sure that you capture the information and that you don't inadvertently fall foul of their requirements. We always recommend to our clients that they should adopt a sanctions compliance policy which is tailored to the individual organization's circumstances and risk profile. And it doesn't have to be a standalone. As I mentioned earlier, it's a component of the broader compliance program. So you can add it and include it in your anti-bribery and corruption or the anti-money laundering policy. And there's no one size fits all. The policy is going to depend on the nature, the industry sector, the size of the organization, and the touch points with some of these jurisdictions like the US and the UK. So risk-based due diligence is so important, and you heard how the failure to conduct due diligence is regarded as an aggravating factor. Remember that South Africa is currently on the grey list. There is going to be greater scrutiny by the FIC and other regulators than ever before. We as a country need to demonstrate to the Financial Action Task Force that we take anti-money laundering, anti-sanctions violations, anti-terrorist funding, all of this, we need to demonstrate that we take it seriously and that we have enforcement. So the regulators are going to be looking for scapegoats. They're going to be looking to make examples of violators. And as Adrian mentioned earlier, when we touched on our government's attitude to Russia, we are under scrutiny already by the US government. So we need to be extremely careful as organizations to make sure that we don't create an example for regulators to initiate enforcement action. We do a lot of discrete due diligence screening, and of course, included in that is the sanctions screening. I got a question the other day, and I don't have Megan, the lady in my team who does all the business intel, on the call, but we were asked how many databases, how many lists do we screen against? And I think the answer that came back was 1,700 and something. I can't remember the exact number, but you've got to make sure that if you are using a range of international compliance databases, you should be covering the following. And what we use are these lists of the Securities and Exchange Commission, SEC and OFAC sanctions, global sanctions list, UK, EU, US, and others. We also look at global law enforcement lists, regulatory enforcement lists, Bureau of Industry and Security lists, UK Companies House disqualified director list, as well as adverse media aggregators. And remember as well that when we engage with a party with a bad reputation, the regulators assumed that we were aware of it, that we did due diligence, and we willingly chose to engage with a bad partner. So make sure that your risk mitigation is optimal and that you're using resources with all of these lists. And it is expensive. We subscribe to multiple enforcement lists because we find that sometimes we have situations where an individual may end up on one particular list that we utilize and not on another. So we try and aggregate and make sure that we cover everything. And if you are a smaller organization and you don't have the resources to actually go and pay the license fees and subscriptions, then it might be easier to engage with an entity like us so that when you do need to screen, you can. But what is also important is put the onus on the parties that you engage with. Make sure that they are screening and that you compel them to do the screening in your contracts with them. So the sanctions, the anti-money laundering, anti-corruption clauses are all there to protect you, and please make sure that you are using them.
Sorry, Stephen. We have got to very close to 1 o'clock, so I just wanted to give you a heads up and
No,
perhaps
absolutely
close off. But thanks so much.
Thank you. And Adrian, on this note, I think we've issued the warning to use the clauses, and if you don't have these clauses in your existing contracts, then I always joke about the program Who Wants to Be a Millionaire. One of the lifelines is you can phone a friend. If you don't already have me in your phone as one of those lifelines, then I suggest you grab my number off our website or off my CV and just put me into the phone, and we'll make sure we get you compliant as soon as possible. Thank you for attending, and I know it's been a huge amount of information that we have shared with you. We hope that a lot of what we've given you is useful. And I thought when we started the session, I wanted to say that we're going to help you get to a comfortable space in terms of navigating the sanctions risk. I think what has to be the overwhelming message from today's session is that this is not a comfortable space at all. And just please make sure that you stay ahead of it. Any last words from you and Adrian?
No, nothing from me. Thanks so much, Stephen. And Jess, I just want to check if you've got anything to close.
Thanks very much, Stephen and Adrian, for what was perhaps an uncomfortable presentation, but a very worthwhile presentation, and helping to highlight that emerging risk, particularly a governance risk for all companies to take into account when looking at their operations and how to ensure that they can amend operations and evolve operations to become more compliant, as Stephen and Adrian have pointed out. So thank you very much to both of you for sharing your knowledge with us today. And finally, just in the last minute, or let's see, it's just gone 1 o'clock. Please do remember that there are still, I think there are 7 masterclasses left. So if you do still need CPD hours, there are still 7 hours available that you could, where you could earn those hours. You can register via the link that you will all have already received when you registered for this presentation. Thank you very much, and we hope to be able to meet some of you at our cocktail parties soon. Thank you. Goodbye.